Parties are in agreement that guideline child support should be set at $654 starting August 1st. Medical support should be set at $211. Parties are both requesting a non-disclosure and are requesting an exchange location at the Chick-fil-A on 1400 East Renner Road in Richardson, Texas, 75082. That is the extent of the agreements. I will now call the mother. Ma'am, can you state your name for the record?
Sheila Dennis.
Ma'am, what's the name and age of the child or children in this case?
Aries Lambert. She's 2 years old. She just turned 2 Monday.
Okay. And ma'am, did you hear the agreements that I read into the record?
Mm-hmm.
Is that a yes?
Yes.
Okay. Are those still your agreements?
Yes.
Okay. Let's get into the contested issues. Are you seeking to be named the sole or the joint managing conservator of this child?
Sole.
Okay. And does a child currently live with you?
Yes.
And you do not live with the father, is that correct?
No.
Okay. Who makes the day-to-day decisions over the child's life?
I do.
Okay. And when was the last time that the father saw the child?
He brought her back Monday.
Because from the very first seconds, the energy in this clip is unmistakable. You can hear the father stepping forward with a mix of defensiveness and determination, laying out his version of financial support. He's not polished, he's not rehearsed. He's simply trying to communicate that he's been involved, just maybe not in the way the mother expected. This opening sets the stage for a classic clash between emotional contribution and legal obligation. It's a moment where personal interpretation runs headfirst into a system that deals strictly in structure, documentation, and consistency.
Sir, I'll get testimony from you in a second, okay? Ma'am, do you live in Dallas County?
Yes.
Okay. And to your knowledge, does the father live in Dallas County?
Yes.
Okay. And is it true that you're requesting that there be no geographic restriction on the child's address?
Yes, because I don't have any support here.
Okay. Ma'am, do you currently have plans to move anywhere else?
I want to go back home where me and him both are from.
Okay. Where is that, ma'am?
Arkansas.
Okay. And ma'am, what type of visitation are you requesting?
I guess on his off days he can get her. But he's not consistent with getting her.
Ma'am, do you understand that in a court order, we need something more specific, that when the father is off?
I don't know his off days.
Okay. Ma'am, do you have any safety concerns with the father having access to the child?
50-50, because I don't know who he has her around.
Okay. Ma'am, would you be in agreement for you guys to do visitation as agreed to? And then if you don't agree on something, for the standard possession order to be in place, where he would have visitation the first, third, and fifth weekends of the month?
Yes.
Okay. And ma'am, are you requesting retroactive support?
Yes, ma'am.
From here, the father doubles down, laying out an uneven but earnest pattern of payments. 500 here, 600 there, even 1,200 at one point. The way he frames it reveals something deeper. He believes contribution is measured by effort rather than predictability. But courtrooms don't work off intention, they operate on consistency and clarity. This part shows the divide between how support feels to a parent doing their best, and how support must be evaluated legally. And that contrast is what sparks many of these disputes long before the case ever reaches a judge.
And the state has calculated retroactive support. And before any credits, do you understand that the state calculated retroactive support for 18 months at $11,160? Do you understand that?
Yes, ma'am.
And ma'am, how has he provided any support to you?
Burley, no, ma'am.
Okay, remind me the age of the child.
2 years old.
Okay, so for the last 2 years, has he given you any money or any financial support?
A few dollars, I would say. Yeah.
What's the total?
That I don't know. Maybe a total of 200, maybe. Spaced out. Like
Okay,
I'll tell him she needs something to eat. He'll send $25 or $15.
thank you. What type of insurance does a child have?
Medicaid.
Is it your wish for the child to remain on Medicaid?
Yes.
Okay, do you have any private insurance available?
No, ma'am.
Okay. Ma'am, is there anything else that the judge should know?
No, that's it. So he will be able to get her on, you said the first, second, and third week of the month?
Do you understand that under the standard possession order, visitation is the first, third, and fifth weekends from Friday at 6 to Sunday at 6? Does that make sense?
Okay. But okay, just one question. What if that doesn't fall on his off days?
It's as agreed to. So
Okay.
whatever you guys can agree to. I pass this witness. I call the father. Sir, can you state your name for the record?
Eric Lambert.
And sir, let's just take this one step at a time. Did you hear the agreements I read to the judge? Sir?
Yeah, you cut out when you said, did you?
Okay. Did you hear the agreements that I read into the record?
Yes, ma'am.
Are those portions still your agreement?
Uh, uh, I mean, I kind of agree with the monthly payments. I mean, that's fine. I did speak with somebody about the insurance part because I do work. I do have my own insurance. They did say something about I could just add on my medical.
Now the tone pivots as the judge takes control, and the informal explanations are replaced with fixed numbers: $654 in child support, $211 for medical starting August 1st. Everything suddenly becomes cold, structured, and official. Both parents agree to a non-disclosure and even nail down a precise exchange location: a Chick-fil-A parking lot. It's such a stark shift from emotional storytelling to legal architecture. This is where personal conflict meets the reality of family law, showing how the system turns lived experiences into enforceable, documented terms.
So, it might be, so I'm gonna
Your Honor, is he breaking
dive
up for
into
you as
that,
well?
Yes.
and
Mr.
then as
Lambert,
far as
Mr.
what
Lambert,
I told them,
Mr. Lambert,
even though
hello?
it's two kind of linked,
Mr. Lambert,
maybe two is close to one, but long story in the hurt.
Mr.
And
Lambert,
like I told my,
your audio is cutting out. I don't know what you're saying. Kind of sounds like a long answer. That's about all I know.
can
So
you hear me now?
we did not hear your answer. So
Can you hear me now?
did you hear me talking?
Yeah, I can hear. I'm just trying to make sure that you can hear me now.
Okay, but don't talk while I'm talking, please. I'm trying to inform you we did not hear what you said at all. And so you need to repeat your answer in a brief way, please.
Your Honor, if I may, I will ask the question a different way that may assist us with these connection issues.
Okay.
Your Honor, Mr. Lambert, do you have your child currently enrolled in insurance?
No, I tried to reach out to her.
Okay, just
No, ma'am.
okay, just answer my question in a minute. You'll have a chance to explain whatever you want to, okay?
All righty.
Is she on Medicaid right now?
I believe so.
Okay, sir. Um, Sir, are you okay with paying child support at $654?
Um, I mean, I do have an additional child that I have to support financially. So,
Is that a yes or a no,
I
sir?
mean, honestly, no, but
Okay. And sir, do you understand that you were given credit for the other child when child support was calculated?
mm, she mentioned to me that they did mention that I
Okay.
have another child, but I don't think she told me with the calculation. Maybe.
Okay. And sir, um, the state is asking for $211 reimbursement for Medicaid. Are you okay with that?
In this section, the judge moves into the verification phase, turning to the mother with calm, deliberate questions. Her name, the child's name, the age, each detail is locked into the record. Her responses are precise and controlled, giving nothing extra. This moment reminds us that courts aren't interested in emotional back and forth, they're interested in accuracy. And through her brief answers, you can almost sense the pressure of the moment, the responsibility of being the primary caregiver and the awareness that every word she speaks will shape the final orders concerning her 2-year-old daughter.
Yeah, that's fine. That's fine till I can. Yes, ma'am.
And you understand that if you're able to find insurance cheaper and comparable, that you're able to enroll your child and then just let us know.
Yes,
Do you
ma'am.
understand that?
Yes,
Okay, perfect. Is it true that you're currently working?
yes, ma'am.
Okay, good. Is it true that you make about $4,700 a month before taxes?
Uh, yeah. Typically, I switch shifts, so I was on night shift, and it's a differential pay, so I did take a pay cut. It ain't much, maybe a couple dollars, but I mean, I can say that's roughly kind of what it is.
Thank you. And are you in agreement to do the exchange of your child at Chick-fil-A on Runner Road in Richardson?
Yes, ma'am. That's fine.
And are you okay with your address and the mother's address remaining private from this court record?
Yeah, that's fine.
All right, now let's switch gears. Sir, is it true? When is the last time you saw the child?
Her birthday was Monday, so I had her Thursday to Monday. So,
Okay. And sir, are you wanting to be named joint managing conservator with the mother, or are you willing to give the mother sole managing conservatorship?
honestly, I kind of want to contest it because a lot of I don't know what type of, like, as far as I don't know what she got going on. I don't know. She don't speak with me about the child as far as doctor's appointments. When the last time she had a checkup or anything like that, it's mostly just financial and just pick up and drop out. So I mean, of course, I want to know what's going on in my daughter's life and the decisions that she make or whatever. You know what I'm saying? So
Then comes the key turning point, conservatorship. The mother requests to be named sole managing conservator, a declaration that carries weight and signals her stance clearly. The judge asks who makes the day-to-day decisions and who the child lives with, slowly building a picture of stability and primary involvement. Her firm, steady responses form a narrative of consistency, highlighting the routines and responsibilities she manages. This portion shows how conservatorship cases hinge on demonstration, not emotion. Whoever proves they provide the structure earns the structure.